Constitution Day 26 November. Ministry of Law and Justice has launched online course on Indian Constitution on the eve of Constitution Day as a part of celebrations of Azadi Ka Amrit Mahotsav for 75 years of India's independence. It is celebrated on 26 November every year. On this day in 1949, the Constituent Assembly of India formally adopted the Constitution of India that came into force on 26 January 1950. It is also known as National Law Day. The Ministry of Social Justice and Empowerment on 19th November 2015 notified the decision of the Government of India to celebrate 26th November as Constitution Day. Next topic, renunciation of citizenship simplified. Ministry of Home Affairs has simplified the process for Indians who want to renounce their citizenship. Provisions have been made for applicants to upload documents online with an upper limit of 60 days for the renunciation process to be completed after verification of documents. Acquisition of Indian citizenship. Citizenship Act of 1955 prescribes three ways: birth, descent, registration, naturalization, and incorporation of territories. Citizenship Amendment Act 2019. It says that to fast-track citizenship for persecuted religious minorities, specifically Hindus, Sikhs, Buddhists, Jain, Parsis, and Christians from Afghanistan, Bangladesh, and Pakistan who entered India prior to 2015. The requirement for them to stay in India for at least 11 years before applying for Indian citizenship by naturalization has been reduced to 5 years. Ways to renounce citizenship in India. Voluntary. If an Indian citizen wishes, who is of full age and capacity, he can relinquish citizenship of India by his will. Termination. If a person takes the citizenship of another country, then his Indian citizenship ends automatically. However, this provision does not apply when India is busy in war. Deprivation by government. If citizen has disrespected the constitution, if obtained citizenship by fraud, citizen has unlawfully traded or communicated with the enemy during a war. Within 5 years of registration or naturalization, a citizen has been sentenced to 2 years of imprisonment in any country. Citizen has been living outside India for 7 years continuously. Constitutional provisions of citizenship. It is listed in the Union list and thus this is under the exclusive jurisdiction of Parliament. The Constitution does not define the term citizen, but details of various categories of persons who are entitled to citizenship are given in Part 2. That is from Articles 5 to 11. Unlike other provisions of the Constitution, which came into being on 26 January 1950, these articles were enforced on 26 November 1949 itself, when the Constitution was adopted. Registration of Births and Deaths Act 1969. Centre has proposed amendments to Registration of Births and Deaths Act 1969 that will enable it to maintain the database of registered birth and deaths at the national level. Presently, registration of births and deaths is done by the local registrar appointed by states. Proposed amendments. Chief Registrar appointed by the states would maintain a unified database at the state level and integrate it with the data at the national level maintained by the Registrar General of India. The appointment of special sub-registrars in the event of disaster with any or all of his power and duties for on-the-spot registration of deaths and issuance. How is it useful? The database can be used to update the National Population Register, Citizenship Act 1955, Electoral Register, Aadhaar, Ration Card, Passport and Driving License databases. Ladakh Resident Certificate Order 2021. Ladakh administration has decided to issue resident certificate only to the permanent resident certificate holders of the region. Unlike Jammu and Kashmir, where new domicile laws allowed outsiders to apply for jobs, lands and other facilities. Objective: It is to temporarily define resident of Union Territory of Ladakh for the purpose of appointment to all the non-gazetted posts born on the establishment of any department or service of administration of Ladakh. Permanent residence certificate. It is a kind of domicile certificate which helps people in availing domicile linked quotas in government jobs and admission in educational institutions. For obtaining a ration card of the respective state, cast the vote in elections, availing the benefits of various schemes of the state, or to claim scholarships of the state. Permanent residence certificate is issued by states like Arunachal Pradesh, Assam, Mizoram, Meghalaya, Tripura and Manipur. Flag Code of India. The first national flag, which consisted of 3 horizontal strips of red, yellow and green, is said to have been hoisted on August 7, 1906 in Kolkata. In 1921, freedom fighters Pingali Venkaiah proposed a basic design of the flag consisting of 2 colors, 2 red and green bands. After undergoing several changes, the tricolor was adopted as a national flag at a Congress committee meeting in Karachi in 1931. The Indian flag was adopted in its present form during a meeting of the Constituent Assembly held on July 22, 1947. Rules governing the display of tricolor. First, the Emblems and Names Prevention of Improper Use Act 1950, the Prevention of Insults to National Honor Act 1971 and the Flag Code of India 2002. The Emblems and Names Prevention of Improper Use Act 1950 says that it restricts the use of national flag, the coat of arms used by the government department, the official seal of the president or governor, the pictorial representation of Mahatma Gandhi and the Prime Minister and the Ashok Chakra. Prevention of Insults to National Honor Act 1971 prohibits the desecration of or insult to the country's national symbols, including the national flag, the constitution and the national anthem and the Indian map. A person who is convicted of the following offences under the Act is disqualified to contest in the election to the Parliament and State Legislature for 6 years. Further, putting any kind of inscription upon the flag, using it to cover a statue, a monument, a platform, and embroidering or printing it on the cushions, handkerchief, napkins or any dress material is also considered disrespect to the tricolor according to the Act. Moreover, the flag should not be allowed to touch the ground or trail in water or be put up in an inverted manner. Third point. In 2002, the Flag Code of India came into effect, which allowed the unrestricted display of the tricolor as long as the honor and dignity of the flag were being respected. The Flag Code 2002 states that there will be no restriction on the display of the flag by public and private bodies and educational institutions except to the extent as laid down in the Emblem and Names Prevention of Improper Use Act 1950 and the Prevention of Insults to National Honor Act 1971. The Flag Code did not replace the pre-existing rules governing the display of the flag. Article 51A Subclause A. It shall be the duty of every citizen of India to abide by the Constitution and respect its idols and institutions, the national flag and the national anthem. Next topic is Employment in Private Sector Bill. Jharkhand Assembly has passed Employment of Local Candidates in Private Sector Bill 2021, which provides 75% reservation for local people in the private sector up to Rs 40,000 salary a month. Once notified, Jharkhand will become the third state in the country after Andhra Pradesh and Haryana to pass such law. Bill can be challenged to violate following articles. Article 14 says that equality before the law or the equal protection of the laws within the territory of India. Reservation to locals are against that equality. Article 15(1) and 15 subclause 2. 15 clause 2 also prohibit the state from discriminating against any citizen only on grounds of religion, race, caste, sex, place of birth. But clauses 5 and 5 to 3 of Article 15 empowers the state to provide for positive discrimination. Article 16 clause 1 equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state. 16 clause 3 it provides an exception by saying that parliament may by law prescribing quote unquote prescribing a requirement of residence for jobs in a particular state. This power vests solely in the parliament, not state legislature. Article 16 clause 3 allows reservation based on the residence by a parliamentary law in matters of public employment and not in private employment. Article 19 clause 1 clause G right to practice any profession or to carry on any occupation, trade or business. Private sector firms can claim that the law interferes with their constitutional rights to carry on their trade freely. In the news, local preference. Maharashtra, private sector to employ 80% domiciled workers, residents for more than 15 years. Status planned था ये, लेकिन implement कभी नहीं किया. हरियाणा ने प्लान किया था ऑर्डिनेंस मैंडेटिंग 75% कोटास फॉर लोकल्स इन प्राइवेट सेक्टर जॉब्स. इसका क्या स्टेटस है? ये भी प्लान किया था, इन्होंने इम्प्लीमेंट नहीं किया. मध्य प्रदेश ने 70% कोटा रखा था प्राइवेट जॉब्स में लोकल्स के लिए. ओनली चिल्ड्रंस ऑफ एमपी टू बी एलिजिबल फॉर स्टेट गवर्नमेंट जॉब्स. इसका स्टेटस क्या है? 70% कोटा अप्लाई कर दिया गया है एंड चिल्ड्रन ऑफ एमपी एट प्लानिंग स्टेज में है. कर्नाटक, प्राइवेट इंडस्ट्रीज टू गिव प्रायोरिटी टू कनाडिगाज इन क्लरिकल एंड शॉप फ्लोर जॉब्स. स्टेटस रूल्स अमेंड कर दिए हैं लेकिन फॉलो अप लॉ पास नहीं हुआ अभी तक. आंध्र प्रदेश अप टू 75% कोटा फॉर लोकल्स इन गवर्नमेंट एंड प्राइवेट सेक्टर. स्टेटस ये भी पास किया गया है और अभी इम्प्लीमेंट होने में समय है. एंड द नेक्स्ट टॉपिक इज वेट. 1 year reservation law unconstitutional. 1 year reservation law unconstitutional. Madras High Court has declared as unconstitutional a legislation granting 10.5% reservation to the 1 year community within the existing 20% quota in educational and public employment for the most backward classes MBC in Tamil Nadu who are 1 years. They were one of the largest and most consolidated backward communities that had a consistency in retaining political representation from 1940s to 1950 and 1950s. They were in the backward classes list for many years. The second Tamil Nadu Backward Commission in 1983 held that their population was found to be 13.01% of the state's total population, consisting predominantly of agricultural laborers. Reason for court judgment. The act was unconstitutional mainly on the ground that the assembly had no legislative competence to pass the law on the day of the enactment. This was because the 102nd Amendment Act to the Constitution was in force in February 2021. The 102nd Constitutional Amendment Act of 2018 inserted Article 338B and Article 342A. Article 338B deals with the structure, duties and powers of the National Commission for Backward Classes. Article 342A, President, in consultation with the Governor, would specify the socially and economically backward classes. Later, the 105th Amendment made it explicit that the state could make changes in their list. Right to protest. Supreme Court observed that it was not against people's right to protest even on matters that are sub judice, but made it clear that such protesters cannot block public roads indefinitely. Right to protest is not an explicit right under the fundamental rights. It can be derived from right to freedom of speech and expression under Article 19, Clause 1, Clause A. 19 Clause 1 Clause B. 19 Clause 1 Clause C. Article 19 Clause 2 imposes reasonable restriction on the right to freedom of speech and expression. Essential Defense Services Bill 2021. The bill seeks to replace the ordinance promulgated in June 2021. It allows central government to prohibit strikes, lockouts and layoffs in units engaged in the production of essential defense services. Provide for the maintenance of essential defense services. Empowers the government to declare services mentioned in it as essential defense services. It amends the Industrial Disputes Act 1947 to include essential defense services under public utility services. The undertakings which supply the basic necessary services such as electricity, water, gas, power, transport, etc. comes under the purview of the public utility services. It also defines strikes and punishments for violations. Present status of right to strike. The right to strike is a statutory and a legal right. The right to strike is a statutory and a legal right. There is no fundamental right to strike under Article 19 Clause 1 of the Constitution. However, it includes the fundamental right to protest, the right to form associations and trade unions. The right to strike has been recognized under the Industrial Disputes Act 1947 as a legal right. Trade Unions Act 1926 also recognizes the right to strike. Next, an institution's right to government aid is not a fundamental right. सही बात है, सुप्रीम कोर्ट ने कहा ये. Top court upheld a 2010 policy decision of the Uttar Pradesh government to outsource appointment of class 4 employees in all state-run and aided institutions and schools. Key highlights of the judgment. Government aid to an institution is a matter of policy and it is not a fundamental right. Article 30 is subject to reasonable restriction. For aided institutions, there cannot be any difference between a minority and a non-minority one. But if an institution does not want to accept and comply with the conditions accompanying such aid, it is well open to it to decline the grant and move in its own way. Article 30 Clause 2 says, State shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Article 30 Clause 1 recognizes linguistic and religious minorities but not those based on race ethnicity. It recognizes the right of religious and linguistic minorities to establish and administer educational institutions, in effect recognizing the role educational institutions play in preserving distinct culture.